Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. I am Judge Milkey. To my right is Judge Hodgens. To my left is Judge Toone. And together we are your panel for the 5 additional cases we're hearing today. In case anyone is unaware, we had a Zoom argument just now, which is why we're late. I should tell you that, it appears that at least most of you are quite familiar with our rules. There's 15 minutes per side, no opportunity for rebuttal. 15 minutes generally is not a great deal of time, so we urge you to the extent possible to cut to the chase, and we'll be happy to help you with questions if you don't. If, on the other hand, you have finished all you have to say before the clock expires, there's no shame in sitting down. As one of my colleagues used to say, if you hit a home run, you don't need to run the bases twice. So with that, I will call the first case of this sitting, Commonwealth versus Sheffield, 2023 P. 1357. Counsel.
Good morning. May it please the court. My name is Ann Rusev, and I'm here on behalf of CARLTON Sheffield. I briefed 2 issues in this case, and I'd like to focus on the first issue, the denial of the motion to suppress. The stop in this case occurred when at least 14 to 15 officers converged on Mr. Sheffield, and one of them said, "Let me see your hands." That command preceded and actually triggered Mr. Sheffield's flight, so his flight cannot be considered in the reasonable suspicion calculus. The Commonwealth failed to establish reasonable suspicion for this stop, and that's because all of the evidence—
You're saying so long as we view the stop before the flight?
Either way, actually. So our position is the command affects a stop, and there's no reasonable suspicion at that point.
What is your strongest case, and I mean one of these cases, for the argument that the command, "show us your hands," was enough?
So I cite 3 cases in my brief, Vick, Johnson, and Prevet. They all deal with commands about hands. So let me see your hands, put your hands on your head, don't move your hands. These were all found to affect a stop. Prevet might be the closest because the Commonwealth conceded that the order, show me your hands, was a stop. So I think Prevet might be the best case on that point. But as I said, even if the command does not affect a stop for some reason, and instead the Commonwealth's argument that the seizure occurs at the start of the pursuit, the only additional factor in play is the flight. And under Warren, it's clear that a black man's flight from the police is entitled to little, if any, weight and must be significantly discounted. So I think the outcome is actually the same wherever you stake the seizure, because the flight simply isn't enough to tip the scales.
What do we do about the fact that the judge made no findings about the recorded statement?
Yes. Well, I think it can be treated as an implicit finding. You can supplement with it because, as the Commonwealth concedes, the motion judge credited the testimony of this officer. So supplementation is appropriate. I think in their brief they say, that there was, the testimony was credited, so supplementation with the undisputed testimony is appropriate. So I think it is appropriate here, and there's good reason for that concession because there's no indication that the judge discredited any portion of the testimony, right? There's about 50 pages of testimony, and she essentially adopts all of Murner's testimony in her findings. Nor is there any preface like there was in Jones-Pennell where the judge says, these are the only facts that I find credible. There's no signifier in the findings that she is limiting her credibility determination to just the facts that are explicitly included in her findings.
The one complicating point to that argument, though, is that she doesn't actually identify the moment of seizure, which you're supposed to do, right? And
yes.
So you could at least make an argument, right, that because she analyzes the case. I think she says at some point that reasonable suspicion kept developing or
Yes.
kept evolving as he went along, that she didn't somehow credit that testimony because she didn't identify that as a moment of seizure. What would you say in response to that argument?
Well, I think that it's important to remember that there was no credibility contest on this issue. There was no impeachment. There was no contrary evidence offered by another witness. So this wasn't in dispute. So there's not a reason that's apparent from the record why she would single out these two facts out of the entire 50 pages of testimony to disbelieve them.
Does the defense have access to the body-worn camera footage at the time of the motion suppression hearing?
I don't know for certain. I don't think it's apparent on the record, but there certainly wasn't any objection where the attorney said, oh, I wasn't provided that or anything like that. So I think it's not totally clear, and I think we'd have to go outside of the record into like the discovery practice.
What if no one heard the recorded statement? Because the officer who testified does not remember anyone saying this. What if it was said under his breath and the camera recorded it, but no one else heard it?
Well, I think the fact that Mr. Sheffield reacts immediately is evidence that he did in fact hear it. The testimony was this command was issued and immediately thereafter Mr. Sheffield took off running. So I think his reaction to that is evidence that he did in fact hear it.
Go ahead. So this is more of like a law school hypothetical, but it's actually a real case. So when Mr. Sheffield and Suspect 2 were kind of in different positions, right? There was stronger evidence that Suspect 2 had something looking like a weapon inside his sweatshirt. And so it's possible that maybe the approaching officer had reasonable suspicion to give that order with respect to Suspect 2. What do we do with that fact, given that the defendant, Mr. Sheffield, was standing shoulder to shoulder with Suspect 2 and then took off, if in fact the approaching officer was kind of directing that comment at Suspect 2?
Right, so I think the inquiry is how would a reasonable person in Mr. Sheffield's shoes interpret that command? That if it was directed at one person or two people, and I think given sort of the massive number of officers that were descending on the scene, Sergeant Murner testifies, it was almost as if the entire day tour of District 4 descended en masse because the police station was right across the street. So you have a huge number of officers converging. You have this command. I think a reasonable person experiencing that would think that this was directed at everybody who's in the immediate vicinity. And Mr. Sheffield's behavior certainly supports the idea that that's how he interpreted it. And I think even if there was...
But if there was enough to give the command, what was the officer supposed to do? I'm directing this command to you, suspect number 2, and no one else.
Well, I think that there were certainly other ways they could have gone about it. I mean, Officer Murner could have gotten out of his car. He could have investigated further before issuing the command. But the fact is the command issued, and it was reasonable to believe that it was also directed at Mr. Sheffield. And I think even if they had reasonable suspicion as to the second individual, you can't transfer that suspicion onto Mr. Sheffield through guilt by association.
Yeah, but wait a minute. But this, I mean, this sounds to me a lot like Terry v. Ohio, where you have Officer McFadden just watching two individuals on the street, walking up and down the street, looking in windows. They do this about 5 or 6 times. Goes up to him, says something to him, they mumble a response. And that was enough, not only for a stop, but enough for a frisk. So said the Supreme Court. So doesn't the fact that these people are acting in concert play a factor?
I think it's a factor to be looked at, but Article 14 and the Fourth Amendment require individualized suspicion. And there's 2 facts that I think are critical in
Are you
showing-
saying the standard, the federal standard is different than the state standard for a stop and frisk?
In this particular situation, no. I'm just saying that they both require an individualized suspicion. And here, I think the two critical facts are that Myrna was clear that Mr. Sheffield was, quote, just sort of standing there with his hands in his pockets, not in an aggressive way. And he was also clear that he couldn't tell if Mr. Sheffield was actually speaking, if he was actually involved in this verbal exchange. So we have a situation where, and the motion judge credited and adopted that testimony in her findings very explicitly. So this is a case that at the time of the stop, the police have no prior knowledge of Mr. Sheffield. There's no evidence that he was actually involved in the verbal exchange. There's no evidence that he himself was making any threatening gestures or postures. There's no indication that he himself had a weapon. There's no bulges, no weighted pocket, no waistband checks, none of the sort of classic indicia of an armed gunman. So based on those facts, there's nothing that can be sort of individualized to Mr. Sheffield. Officer Murner, or Sergeant Murner, excuse me, is a trained observer, and he was able to testify in detail as to what was happening in the pocket, what the other gentleman was doing with his hands, sort of the beckoning motion. He did not testify to any action, any gesture, any behavior on behalf of Mr. Sheffield that indicated he was actively participating in a crime or about to commit a crime.
Except he was shoulder to shoulder with this other individual.
He was shoulder to shoulder, that was a testimony.
And they were approaching the third individual. They were closing the distance between the two and the one, right?
Well, I think that the testimony was, initially they were about 100 feet apart. They were across a parking lot. And at some point they got closer. It's not clear exactly, but they never got very close, I think was the testimony. So the
Not as close
officer-
as he was to the assistant DA in the courtroom.
Yes,
But
exactly.
they closed the distance from 100 feet to something much closer while yelling. They're yelling angrily at him, right?
Well, somebody was yelling angrily. We don't know who. We don't know how close they ever got. All he says is it wasn't very close and never as close as the distance between the DA and him as he sat on the witness stand. So I don't think that there's evidence in the testimony that there was sort of like multiple advancements. All we have is at some point they got closer but never very close. So there's not an indication that there's an immediate assault and battery that's going to happen because they never get close enough to have physical contact.
No, but the police see an escalating situation between these people. They have at least some reason to think that one of them may be armed. Why wouldn't we want the officers to intervene in that circumstance from just a community caretaking perspective?
Well, they certainly can intervene, and there were steps they could have taken short of an immediate non-consensual stop. Murner could have gotten out of his car and said, like, hey guys, what's up? There's ways to engage with a person conversationally without affecting a stop
But if
immediately.
they had a reason to do a stop, not a seizure, but just to engage with the individuals, why isn't this like a car stop where there's a reason to stop the car, and in doing so, the police can say, put your hands on the dashboard?
Well, in the situation with a car stop, we have sort of a separate jurisprudence about how dangerous car stops can be for officers. And for example, the standard for an exit order is less than the standard for a frisk in recognition of the dangers posed by car stops. So certainly the officers can approach, they can have a conversation with them. If they have reasonable suspicion as to the second individual, they could issue him a command. They can say, hey, you, let me see your hand, something like that. But they can't, in the absence of any evidence that Mr. Sheffield had personally engaged in any behavior that suggested he himself was about to commit a crime, they can't effect an immediate non-consensual stop of him.
I totally take your point about Ibarra, and you can't just establish reasonable suspicion based on propinquity, that's how you say it. This does seem like it's a little bit different where there's threatening behavior by one person and someone who's standing really close by in a way that seems like they're acting together. It seems like a slightly different situation, which makes your case harder here. So I don't know how to process that, but what would you say?
Well, I think certainly there could be a spectrum between, bystander that's completely removed from the situation but present, and then somebody who's present in a little bit closer proximity. But until that person who's present actually does something to indicate that they're actively involved, like any of the things the second suspect did, like making a gesture with his hand, yelling something audibly that Murner could hear, doing something with his body, blading his body, a security check, something like that. There's nothing to individualize it to hair. And I think, individualize it to Mr. Sheffield, excuse me. And I think when it comes down to it, close proximity is still just mere presence. In the absence of some interaction either between Mr. Sheffield and this second individual that shows that they're, planning something together or they're conversing together about what's going to happen next, or some indication that Mr. Sheffield is communicating directly with this other person, you're left with presence, and close presence is still just presence. I see that I am almost out of time. If I could, if there are any other questions.
Thank you.
Hearing none, thank you very much, Counsel. We will hear from the Commonwealth.
Thank you very much.
Good morning, Your Honors, and may it please the Court, Kate Freeman for the Commonwealth. We're asking the Court to affirm the decisions both of the motion judge in denying the motion to suppress and also the trial judge in allowing the Commonwealth's request for a consciousness of guilt instruction. Turning to the first issue with the motion to suppress and reasonable suspicion, the defendant's challenge fails as the officers were justified in stopping the defendant based on reasonable evidence that he was committing or was about to commit a crime. While the motion judge did not point out, as Your Honors noted, a specific moment of seizure, I think that the record, rulings, and findings support the reasonable inference that the defendant was seized at the moment he fled with the unidentified co-defendant immediately upon seeing the police. Regardless,
Could you address, though, that why counsel is wrong that the seizure occurred upon the command to show your hands?
Sure. So, as Your Honors noted, the motion judge didn't even mention, "Let me see your hands," in her decision, her oral decision that was provided to the court. That Sergeant Murner testified that he himself didn't hear that command. There was no evidence that the defendant or the co-defendant heard that command. Sergeant Murner
How about the fact that he took off at about exactly the same time?
So I think that there's an inference that can be made that the flight perhaps occurred simultaneously to that statement, or there's just no evidence to support that the defendant heard it. The motion judge stated in her findings specifically that, one moment, immediately upon seeing the uniformed officers, they fled and the officers gave chase. She doesn't state that immediately upon hearing that statement, they fled and the officers gave chase. She says that she finds that it's immediately upon seeing the officers that they flee. So I think that the inference can be made that we can consider the flight in the reasonable suspicion calculus, along with the other factors, which I'm happy to get into.
But the motion judge didn't make a ruling as to when the seizure occurred.
No,
right?
she didn't.
She didn't, right. And it doesn't seem like this fact is adverse to what she did because she didn't make that particular finding. You don't deny that this evidence exists, that the body, it shows us in the body-worn camera footage.
It does.
Right? It does, okay. So I just try to assess it. How do we consider that? Because, you in your fact section, you supplement the judge's facts with all sorts of different aspects of Sergeant Murner's testimony, and sort of this is one thing that's kind of left out, but seems kind of critical to one of the issues. So I just don't know, what would you say about how we should approach that issue?
So I think that even if you consider "let me see your hands" as the moment of seizure, I think that the Commonwealth still prevails, because I still think that there was reasonable suspicion at that moment to stop and seize the defendants. I think that regardless of whether whether the moment of seizure was when the police began chasing him in response to the flight, or if it's after an officer on body-worn camera that I would note was not entered into evidence at the motion to suppress. Officers still had reasonable suspicion based on specific articulable facts of what Sergeant Murner had witnessed. I think it's notable that there's no evidence of anyone hearing that statement. I think that had it been a significant issue at the motion to suppress in terms of did the defendant hear that statement, I think the judge would have noted it in her findings, that it's clear that the moment he takes off is right after hearing that.
Don't you need the defendant to establish
Right.
definitively that he didn't hear it, and he
You
doesn't
would.
have to testify?
You would. You would. There's just no evidence to support how that was received, if it was heard. As counsel noted, there were a significant number of officers who responded when Sergeant Murner broadcast his call on Channel 5, and that's due in part to what his call was and also to the proximity of where he was to Boston Police Station District D4, which was right across the street.
Well, correct me if I'm wrong, but didn't the officer testify that he initially said they fled upon sight of the approaching uniformed officers, and then he corrected himself and said, well, one of the officers did say, let me see your hands. So based on that testimony and then what the judge said as she dictated her findings, she certainly didn't credit anything about someone saying, let me see your hands, and she certainly didn't credit any testimony, because there was no testimony, that the suspects fled because someone said, let me see your hands. Is that?
That's correct.
Am I reading that correctly?
That's my interpretation of it, is that she didn't give it much weight in her, if any weight, in her decision. Otherwise, it would have been noted in her decision. She would have, if the moment of flight, or if the moment of seizure was after that statement when they took off, as opposed to what she said, which was that it was immediately upon seeing the officers, I think she would have noted that.
In other words, what seems critical is the officer didn't hear at the time that someone said, let me see your hands. It wasn't until later when he reviewed the body cam footage that he realized, oh, someone said, let me see your hands.
That's correct. If there are no further questions on this issue, I can move on to the consciousness of guilt.
I just want to make sure I understand your answers. The judge took the flight into account, correct?
She did.
So doesn't that implicitly establish that she thought the point of seizure was at that point, not at an earlier point?
That's the Commonwealth's position, that the reasonable inference to be made is that that's the moment of seizure.
And so are you saying that she therefore implicitly did not credit that the show us your hands occurred before, or was she saying, I don't find it significant? It didn't constitute a seizure.
So, she did credit Sergeant Murner's testimony. I think, I can't speculate as to what might have happened if that body-worn camera had been introduced into evidence.
Well, I mean, the body cam wasn't in evidence, but it was in evidence what was said there, correct?
Correct. In the sense that Sergeant Murner said that when I was preparing for this motion, I reviewed body cam, and in that reviewing of the body cam, I saw another officer say, or heard another officer say this. I think she didn't give it much weight.
So how can we determine there appear to be at least two inferences we could draw to explain what the judge did, and they cut in different directions. What are we supposed to do with that?
I think that no matter when you determine the moment of seizure, either at let me see your hands or the moment of flight, if it's prior to let me see your hands, I still think that at either of those moments, there was reasonable
If the point of
suspicion.
seizure was upon, I want to see your hands, what specific articulable facts established reasonable suspicion for this defendant?
Sure. I think that that the defendant acting in concert with the unidentified co-defendant is significant. Sergeant Murner testified that they were engaged with one another. He testified on page 24 that the two suspects, quote, definitely engaged with one another, and they were definitely going in the direction of the third male, meaning that he saw them interacting with each other, Mr. Sheffield and the co-defendant, and then saw them both moving towards the third male. Mr. Sheffield didn't just stay put when the co-defendant started moving closer to the third male. He himself moved with the third male.
But Sergeant Murner also made a point to testify, and I think his evidence was very credible, that the defendant was just sort of standing there, I believe, with his hands in his own pocket, not in an aggressive way as the other male. He did draw a distinction between the two.
Yes.
So that's, I mean, certainly if this were suspect 2 in this case, seems like a pretty strong case, but the main expert kind of drew a pretty stark difference between the two of them. And
he did, and there was a difference between the two of them. However, if you look at the defendant's actions in a vacuum and only consider what the defendant was doing and don't consider what the co-defendant was doing, they might appear innocent, but you have to view them together, and it's the Commonwealth's contention that they have to be viewed together. They're standing shoulder to shoulder. They're in this heated discussion where Sergeant Murner testifies he hears voices, plural, even though he's not able to distinguish whose voice is whose, but that those voices are going in the direction of this third individual. He sees the co-defendant gesturing, which he demonstrated on the record, that the co-defendant has his hand in his pockets, pointing it out like this and gesturing for the other man to come towards them as he and Mr. Sheffield are moving closer to that third man. And Sergeant Murner testified why that was so concerning to him based on his training and experience, that what the co-defendant was doing and why this whole interaction was so concerning for him.
And what was the evidence that they were acting together? It was standing shoulder to shoulder. What anything else?
Standing shoulder to shoulder. He testified multiple times that it was voices, plural. He kept saying voices.
Though he kind of moderated on that, said wasn't sure.
Right, but he said, but I heard voices going in the direction of the third man, and then they're moving closer. If Mr. Sheffield was an innocent bystander, he could have stayed put. He didn't have to take the steps, the literal steps, towards the third man with the co-defendant, as the co-defendant is gesturing with what Sergeant Murner fears is a gun.
If, this is pure hypothetical, were we to determine that the question of reasonable suspicion turned on when the seizure here occurred, and that we can't figure that out implicitly from the judge's findings, what's the remedy that would be appropriate now that the trial has already occurred? Can we remand?
So the standard is that the court will accept a motion judge's findings unless there is clear error, and the court will independently determine the correctness of the judge's...
I know the standard of review, but in terms of the remedy.
Frankly, I'm not sure what the remedy would be in this context. I would be happy to research the issue and file a supplemental...
Just to be clear, if we want a supplemental brief, we will ask for it.
Okay. I'm not sure what the remedy would be. However, I think that the judge's decision stands. I think that irregardless, as I stated, of when that exact moment of seizure was at let me see your hands or the flight, her decision and the denial of the motion to suppress is still sound.
Wasn't the judge required to find when the moment of seizure occurred? Isn't that sort of essential to this analysis? And she didn't really do that.
So I think it's certainly customary. She certainly made clear what factors she considered in reasonable suspicion. She did not issue written findings in this case.
But even in oral findings, it was just, that's, you look for that kind of critical decision, and it's not really there.
Right.
You have to kind of read into maybe she meant this, maybe she meant that.
Right. So I think that the best thing that anyone involved in this can do is we have to make reasonable inferences and see what her findings do say and what inferences can be drawn from those.
And am I correct that the Commonwealth never put forward a community caretaking reason for approaching the group of 3 men?
Correct.
Okay. Does that mean you're waived from raising it now, given that it wasn't put forward as a constitutional justification for the initial approach?
No, I don't think that it's waived. However, it wasn't considered by the motion judge in her findings. It wasn't an argument that the Commonwealth made.
You have almost 2 minutes left. Would you like to address the other issue?
Sure. So with regards to the consciousness of guilt instruction, the trial judge did not err in giving the consciousness of guilt instruction in which he instructed the jury that they could consider the defendant's flight as evidence of guilt without also providing whatever this language from Commonwealth v. Warren might be. First and foremost, the trial counsel never requested supplemental instruction. All he did was object to the giving of any instruction. He didn't say, I'm objecting because there are many reasons why a black man might run from the police, and if you give this instruction, here's what you should say. He just said, I'm objecting because there's many reasons in 2022 America why a black man might run from the police. Because he didn't request any additional language that counsel is now requesting, his claim here should now be viewed only as to whether or not there was any error in the instruction as it was given to the jury. There was no such error in that instruction, and there is no substantial risk of a miscarriage of justice here. I think it's also important to note that in both briefings by the defense, counsel doesn't specify exactly what language she would like to have added. Counsel just references that an incorporation from Warren should have been added. But again, that was never argued by defense in limine or during a charge conference at the trial. It was not argued in his closing. There was no cross-examination about race with any of the officers who testified. And even still, the trial judge in his instructions said, quote, that the jury should remember that there may be numerous reasons why an innocent person might do such things and that such conduct does not necessarily reflect feelings of guilt. It's not clear to me how that's insufficient.
Counsel, I'm afraid your time has expired. Thank you both very much. The case is submitted.
Thank you.
Our next case this morning is 2023 P975, Commonwealth versus Sanchez.
Morning, if it please the court, Joseph Asone for Mr. Sanchez. As you said, Justice Milkey, cut right to the chase, and that's exactly what I propose to do. If you remove Trooper Gadarowski's arguably hearsay statement in terms of identifying the perpetrator of the crime, if you agree with it that it was hearsay and it should have been objected to, then at the end of the day, the question is, was there enough residual evidence, circumstantial evidence, presented to the jury so that they could make a finding beyond a reasonable doubt that the person sitting at counsel table with his attorney was in fact the same individual that Trooper Dunderdale witnessed during his surveillance activities make a controlled buy. And arguably, if this, there was an objection, if there wasn't an objection and I had to rely on a substantial risk of a miscarriage of justice, I think it would be a much, much closer question. But given the prejudicial error standard, I believe that the jury might be in a situation where they don't have an identification in court that this is the guy who committed this crime, because the Commonwealth believed, rightfully or wrongly, that they had a Creighton issue. Whether they had one or not, it's irrelevant, I guess, at this point, because Trooper Dunderdale never said, that's the gentleman that I witnessed.
No, I understand that.
Right.
But we had the arresting officer testify that the defendant sitting in court was the person he arrested, correct?
Correct. That's proper.
And so the only link that you allege is missing is whether or not they arrested the right guy. And just bear with me for a second. Both sides have tended to focus on the testimony of Gadarowski, to whom we can refer as the arresting officer. But Dunderdale already testified
Correct.
in the case.
Right.
And he said, without objection, my job was to watch and to give the signal.
Right.
And then he said, and I gave the signal. Again, no objection.
Right.
So that came in.
Correct.
Now, leaving aside whether the jury, based on that alone, since his eyes were on the whole time, is enough that they got the right person, he goes on to say, I'm looking at the transcript at page 137, and what the question is, and what did the supporting officers do when they came onto the scene? Answer, they immediately went over to the two individuals that were on Kibbe Street, the side of the fence from that house, Marcos, the co-defendant, that I interacted with, and the other individual that he made the exchange with. Why doesn't that alone, together with the testimony he already gave about giving the signal, and that he gave the signal, enough to connect all the dots?
Well, that's the issue. I mean, that's all circumstantial evidence that the jury would have to draw an inference.
Is it circumstantial? He's
Well, I think
saying,
they'd have to draw an inference that what Gadarowski did, which in terms is, I arrested this individual that's seated at council table, and Dunderdale's testimony, you know, I never lost sight of anybody. It was a gentleman came out, he had no shirt on, he had a beard. I don't know if he had a beard in the courtroom. Would have been smart if he shaved it, but in any event, you know, he gave a physical description, and the immediacy of everything happening, again, as I said, if this was a substantial risk standard of review,
No, but I think what my colleague is
In
saying
very
is
good shape.
Trooper Dunderdale sees the arrest of the defendant.
I'm sorry, Your Honor.
Trooper Dunderdale watches the arrest of the defendant, sees it happen. Isn't that sufficient?
Right.
To establish the defendant's
he stayed
identity?
long, he saw the arrest, he stayed long enough to tell Gadarowski that, yeah, that's the people that I saw.
But he
doing the
testifies that he
hand-to-hand
watched
thing.
it happen, right?
He watched it happen, he testified, I never lost sight.
Yeah.
And so the question is, I mean, it seems pretty obvious for lawyers, because we understand, you know, putting together all these different inferences, that it would be the same individual. There's no other individual there. The question is, at a lower standard review, would that have been enough for a jury to make the conclusion that, the guy that's seated at counsel table with his lawyer, the defendant, is the same person that Trooper Dunderdale observed engaging in a distribution of an illegal substance? I mean, I'm kind of looking at this through the eyes of, you know, a jury who's not schooled in what we're schooled in, and whether or not all of those inferences could have been linked together.
Well, there's another, on page 157 of the transcript, there's an exchange where Trooper Gadarowski is being examined, and the question is, and this individual that wasn't wearing a shirt, that's correct. And how was he identified? The answer, Springfield PD narcotics officer. Initially, Trooper Dunderdale, the UC, pointed him out that he was involved, and later Springfield PD narcotics officers identified him as his name. And what was his name? Louis Sanchez. So isn't that enough, coupled with the other evidence, to satisfy the identification that this was the guy?
Well, I think that there was an objection to what he said Dunderdale had said. Because when Dunderdale says he confirmed, that's you know, a type of hearsay. It's nonverbal hearsay if he just said, that's the guy, okay? Because Gadarowski has no personal knowledge in terms of who committed this crime. He was on the other side of the road in a surveillance position. He was out of eyesight. He said, he testified, I did not witness this. So the only way he would know if the person seated at counsel table was the guilty party was what Dunderdale had.
If I can
I'm sorry.
unpack the question,
Sure.
as I understand it, if there's a disconnect here, it's because there is no objection at this point. And your argument, I take it, is that trial counsel was excused from objecting because they had just objected.
Right.
And it was overruled. So you're reading the transcript as if there were an implicit objection here.
Right, I mean, he'd already been overruled, and he's asking the same thing, so am I going to go up and object again? You just told me that it's okay. I mean, the judge just told me,
But why is
Rule.
that, my question is, why is that any different than any other out-of-court identification? If someone, let's say there's a show-up, and the officer testifies that, yeah, well, the witness pointed the guy out and said, yeah, that's the guy that robbed me. I mean, that's not hearsay. That comes in, that's an exception to hearsay. So why would this be a problem?
well, it's a problem because Dunderdale never identified in court that the person he observed committing this crime was the person seated at counsel table, i.e. the defendant.
You're also saying, I take it, that the arresting officer never saw the transaction.
The arresting officer,
so he
my
can't say
understanding,
this is the right
never
guy,
saw the
except-
transaction. He only knows he arrested the right guy is because his colleague, Trooper Dunderdale, told him, you arrested the right person. Now, again, there weren't very many people around the area. I mean, there was just, there wasn't 10 or 15 shirtless, bearded men walking around at the time. So again, if this was a substantial risk situation.
What about the Commonwealth's argument that that identification really wasn't an issue, that the defendant wasn't disputing that he was there, he was just disputing why he was there, that he's just really getting a soda, he's not selling drugs?
Well, he's disputing the fact that he was selling drugs, that if he was, he didn't testify, so the jury doesn't have that before them, that he's not contesting the fact that he was even there. There was no evidence presented by the defense that, he could have, but he didn't. It was all the Commonwealth's case. So where is the evidence that he says, oh, I was there, but I was doing other things? He didn't testify to that. He never took the stand. So where's the evidence? Where's the evidence of identification other than what Gadarowski said? Okay, so again, if you remove what Gadarowski says, is there enough left over so that that a lay jury, and I underscore the word a lay jury, would have been able to connect the dots? It's very easy for lawyers to connect the dots or for justices to connect the dots. The question is, can a jury that has no legal training whatsoever be placed in the same position where they would be able to connect the dots? And if there's no more questions on that, I would just briefly touch on my second argument is that the standard is preponderance of the evidence. The judge didn't say preponderance.
I'm a little unclear as to what you're arguing. Are you saying that the jury could have concluded that the standard was something less than preponderance of the evidence?
Well, again, these are legal terms. These are terms of art. We understand what preponderance is. We understand the difference between preponderance and beyond a reasonable doubt or clear and convincing evidence, which is a standard for actual innocence.
But aren't you implicitly arguing that this is something less than a preponderance? The jury could have concluded that.
We don't know what they used. It could have been. They may not have even come to the realization that they had to make the conclusion or come to the conclusion that, yes, this was a joint enterprise. Now, since we found that this is a joint enterprise, they may have just assumed that it was a joint enterprise. Again, there's a difference between, the way we see things and the way a lay jury sees things. It's not the same. If there's no other questions.
Thank you very much, counsel.
Thank you.
We will hear from Ms. Simonian.
Good afternoon, Your Honors. May it please the Court. My name is Elizabeth Simonian, 303 certified student practitioner, arguing on behalf of the Commonwealth and under the supervision of ADA Travis Lynch. Now, today, the Commonwealth respectfully requests that this Court affirm the defendant's conviction for distribution of a Class A drug. And I'll begin with the issue concerning the trooper's alleged improper hearsay identification testimony, and then finish with the issue concerning the joint venture jury instruction. So looking at the first issue, the trial judge here did not commit reversible error in overruling the defendant's objection at trial to Trooper Gadarowski's testimony. This testimony was offered for the non-hearsay purpose of explaining police action or knowledge.
Why was that needed at this point, where Dunderdale had already testified, explained the roles of the various officers, explained that he was there to give the signal, explained that he gave the signal? How would anyone be confused in terms of why the other officer arrested?
So looking at the trial transcript, we see that the trial prosecutor relied on Ortiz in that had she asked Trooper Dunderdale to identify the defendant in court, she would have created...
No, but that's a separate issue. In terms of, I heard you say that the purpose of the testimony, that they arrested the right man, was to explain why they arrested somebody. And I'm saying, why was that necessary where Dunderdale had already explained the various roles? Would a juror really be surprised by, oh my God, this guy arrested him for no reason, when Dunderdale said, I gave the signal?
I mean, maybe a jury wouldn't have really been surprised here. The Commonwealth was simply offering this to show that he had received that done deal signal from Trooper Dunderdale, that Trooper Gadarowski had received that done deal signal, and that he acted on that information.
Dunderdale already testified to that.
He did, correct. So arguably there may not have been any confusion by the jury. The jury could have seen that as, they could have made the inference that he was the man who did it. And at the underlying trial, like Your Honor had mentioned, ID was not seriously contested anyways. So we're looking here at a defense on page 127 of the trial transcripts. You can see that defense counsel at trial characterized this as a wrong place, wrong time defense. So in any event, ID is not a huge issue at the trial below.
Isn't it always the Commonwealth's burden to prove ID? So how can you say it wasn't an issue at the trial?
It is an issue, but in terms of the theory of the defense here. So we can see that the defendant put on witnesses that supported his theory that he was possessing a Coca-Cola bottle and a water bottle rather than the heroin he was distributing.
Yeah, but that was after the Commonwealth's case, correct?
After the
That was his witnesses.
Yes, he did.
Okay, what do you do with the fact that I'm looking at page 177 of the transcript, where defense counsel was arguing for a required finding, and specifically, trial counsel specifically highlights that there was no evidence proving identity?
Well,
Doesn't that show that even as a matter of fact, the defendant was contesting identity?
There, it does show that the defendant was contesting identity. However, I would say, to that, I would say, on 177, I'm sorry, let me just take a look here. I would say he was contesting identity in that he didn't believe, I mean, there was circumstantial evidence here. I believe there was power, the Commonwealth's position is that there was powerful circumstantial evidence. You put both of those troopers' testimony together, and it's quite clear that the officer who engaged in the undercover narcotics transaction, he never lost sight of the defendant. He saw him up until the time that he was arrested. No one else engaged with the defendant or his co-venturer at that time. And then you put the second officer on here, and he testifies that he also shows up to the same exact location that he was directed to. The defendant was still shirtless standing there at that fence. It's clear that the question here is not about identity. It was focusing on the fact that he was trying to rebut what he was actually possessing here. And so
And can we add something to that as well, that as I read what the argument is, Your Honor, one of the biggest issues we find in this case is that when Trooper Dunderdale, the UC, testified, he described who was the person that bought from the other individual, but he never identified my client. Isn't that more of the point that he was making that, well, the UC never made the ID,
Correct.
but but the identification can be made in other ways. You don't necessarily have to have the UC on the stand saying that's the guy.
Correct. And that goes to the interpretation of the facts here. As my brother had briefed it on page 9 of his brief, footnote 1, he talks about that there was good reason here to have that first trooper identify the defendant in court. And if that was true, that we could have, then the second trooper statement wouldn't have been error here. It would have been properly admitted. So there would have been no prejudice to the defendant.
Yeah, but you can't claim no prejudice based on evidence that was not ever offered. Shouldn't what have happened here is just the prosecutor ask one more question, which is the question the prosecutor then tried to get through the arresting officer. You know, did they arrest the right guy? Yes.
Yes.
End of story.
And I think that just goes to, that was the interpretation of Ortiz here. So the Commonwealth brought Ortiz in here and briefed this issue the way we did out of an abundance of caution, because we saw that we didn't view the facts as that first trooper having made a prior out-of-court ID. Here we saw that if that trooper was asked to identify the defendant in court, it would have been viewed as an inherently suggestive in-court show-up. And there was not good reason pursuant to Ortiz, as the Commonwealth viewed it, to allow that officer.
Isn't that a red herring? Because Dunderdale clearly could have answered the question that was never asked about, did they arrest the guy you saw do the hand-to-hand?
Arguably, yes, he could have made that ID. I think that it just based off of looking at the transcripts and how the trial prosecutor saw Ortiz, she didn't ask that first trooper to identify the defendant in court because she was afraid that she might have created an error.
But forget the identifying in court. I'm talking about commenting on the observations Dunderdale made at the scene.
Okay.
Which, frankly, he came very close to saying. It would have been nice for that last question.
So yes, he could arguably have made that identification in court. And if he did, that second trooper statement would have been admissible. But in any event, here, there was enough circumstantial evidence to prove the defendant's identity beyond a reasonable doubt. Like I had said, we put both those troopers on the stand, and they both testified to a clear chain of events that shows.
But the issue isn't sufficiency, correct? The
Correct,
issue
it's not
is
sufficiency.
whether there was sufficient prejudice. Could you address the waiver issue in terms of the lack of an objection the second time the prosecutor went down this path? The argument you heard was that since the objection was just overruled when the question was asked a second time, defense counsel didn't have an obligation to object again, something that presumably would arguably have cost him with the jury. And since he knew how the judge was ruling, there was no obligation. What's your response to that?
My response to that would be if we can look at the prejudice standard and have enough evidence here to show that, this statement the first statement wouldn't have prejudiced the defendant because there was no objection to the second statement, we fall under the substantial risk standard, which is lower than the prejudice standard. So if we can win on the prejudice standard, then we would win on the substantial risk standard as well because it's a lower standard. And so for most of the same reasons, the ID was not seriously contested at trial, and the fact that we put on the troopers who testified to that clear chain of events that he was the person, then there was no substantial risk based on that second statement either. And both statements here were admissible for the non-hearsay purpose of explaining police action or knowledge. So,
well, can you just explain that to me? Because there wasn't any kind of limiting instruction about how this evidence came in, right?
sure.
And the question that started it all off was, when you arrested the two individuals, what confirmation did you have that you're arresting the correct people, right? So the
Yes.
question was, give me the substantive information about the confirmation. It wasn't about explaining to me police action, right? So I'm trying to understand, how do we invoke this police action hearsay exception when that's clearly not the purpose of how the question was asked?
I think that if the court sees this as a backdoor to introducing an ID, even though the Commonwealth here wasn't the Commonwealth here wasn't using the trooper's statement to offer it as substantive evidence of the defendant's identity. You know, the trial prosecutor even gave an explanation of that to say, you know, there's enough evidence here. And so
It seemed like a front door inquiry. I mean, what confirmation did you have, the arresting? I mean, he's asking the actual question for the truth of the matter asserted, right?
The Commonwealth here was entering this statement to show that Trooper Dunderdale gave Trooper Gadarowski information, which was specifically that done deal signal, and that he acted on the information he received to arrest the defendant and to show that they weren't just picking up random people. They were arresting the correct people. But because the identity was not seriously contested at trial, it wouldn't prejudice the defendant or create a substantial risk because, again, it was not the theory of the defense at trial here. We're focusing on the witnesses that the defendant put on and the fact that the trial prosecutor rebutted the witnesses that the defendant put on to show that an experienced trooper wouldn't have made a prior agreement over the telephone to purchase a Coca-Cola bottle for $60. We're not looking exactly at identity as the defense. We're trying to show here that we're rebutting the wrong place, wrong time defense that the defendant characterized for his theory of the theory of his defense. So here, the Commonwealth's position is that there was no error, even if there were error, for the reasons I have stated.
I just have a quick academic question for you,
Sure.
because the defendant, it seems to me, correctly points out in the first footnote in the brief that there really wasn't a Creighton problem here at all. Would the Commonwealth agree with that now, that that UC could have testified that, yeah, that's the guy that sold me the drugs?
Arguably, yes, he could have identified the defendant.
Because this isn't the Ortiz case, because in Ortiz, the SJC pointed out that immediately after the officer's name, Manasone, left the vehicle and informed the other officer, Bruno, that the sale had been completed, Manasone returned to the police station.
Sure,
So he wasn't involved in the arrest at all, where this undercover trooper was involved because he was actually telling the arresting trooper, yeah, that's the guy, he was involved.
So as a gray area, the Commonwealth viewed Ortiz good reason that the officer had to actually be putting the cuffs on the defendant or standing with the arresting team. It's not clear exactly where the officer was standing here. We know that he viewed the arrest of the defendant, but we believed Ortiz only applied where he was an eyewitness to the commission of the crime and actually was participating in the arrest of the defendant. So out of an abundance of caution and because it was a little bit of a gray area, that's the reason we briefed it that way. Now it might seem clear that that's not the case, but that is the reason why we did brief it that way. If there are no further questions on this issue, I'd like to move on to the joint venture jury instruction issue. Great. So here, it is true that the Commonwealth agrees that the trial judge did commit an error in this case. However, that error, by omitting the 4 words, preponderance of the evidence in that joint venture limiting instruction, it comes from the district court model jury instructions, which are wrong. Those instructions were last revised in May 2011 to reflect the changes in Zanetti, but they were not updated in 2012 after Bright came out to reflect the standard, including those 4 words, preponderance of the evidence.
To the extent the Commonwealth feels the district court model instructions are wrong, is it fair to assume the Commonwealth is doing something about that to try to get the instructions changed prospectively?
So the Commonwealth here is not responsible for maintaining or approving of those, and as we understand, the appellate court and the SJC also does not review or approve those instructions. In light of the confusion created by those instructions here and maybe in future cases, the Commonwealth believed it may appropriate for those instructions to be amended, whether that is a request made by us or some other way. However, we do believe that those instructions need to be amended just so that we can prevent errors like this. Simply because those 4 words are that's the only issue here, is that those 4 words were omitted. But in the briefing, I pointed your attention to Commonwealth v. Lowry. A joint venture statement was admitted. The trial judge entirely failed to provide that instruction here. the instruction was given, it was just those 4 words that were omitted. In fairness of time, if there are no questions on this issue, the Commonwealth believes that there was no substantial risk here. So we ask that we respectfully request that you affirm the defendant's conviction below. Thank you.
Thank you very much. I understand this was your second argument.
This
is
is.
it? Congratulations.
Thank you.
The case is submitted. Our next case and the last one we take before a brief mid-morning break is 2023 P171 Commonwealth versus DEMELO. Counsel.
Good morning, Your Honors. Hannah Taylor on behalf of Mr. DEMELO, who is here with us today. Mr. DEMELO is entitled to a finding of not guilty because there was insufficient evidence to support his conviction on the only legal theory to be submitted to the jury, that Mr. DEMELO knowingly violated the 209A order here by committing direct abuse, defined as placing the complaining witness in fear of imminent serious physical harm. And there's insufficient evidence that he committed abuse through the call with the complaining witness, as there was no evidence that he had notice of the order or any of its terms at the time of that call. There's also insufficient evidence that he abused the complaining witness by being outside of her home, although the complaining witness's mother testified that he told her he was outside the complaining witness's home. She followed that up immediately with, and he wasn't even there. The complaining witness herself also testified that Mr. DEMELO was never outside of her home.
No, but was that, focusing on the mother's testimony,
Yes, Your Honor.
was her statement that he wasn't even there a statement of her opinion? Because there is the evidence that he told her that he was outside the home. So just drilling down on that fact, why couldn't the jury conclude that he was outside the home, notwithstanding the mother's testimony that she didn't believe he was outside the home?
So there was no other corroborating evidence, including from the testimony of the police officer, that when he was at the home, the only person that he saw there was the complaining witness herself, not the defendant. Additionally, the complaining witness testified that Mr. DEMELO was never outside of her home as well, and because the definition of abuse requires that the complaining witness be placed in fear of serious imminent physical harm, which closely approximates the definition of assault, which requires awareness.
You're saying whether he was there or not is in the end irrelevant because it was presented to the jury as an abuse case, not a no contact or stay away from.
Yes, correct, Your Honor. And finally, the statements that Mr. DEMELO made on his calls with the complaining witness's mother also cannot constitute, or also were insufficient to sustain the conviction on a theory that he violated the no abuse provision, because a third-party act would be required, namely that the mother informed the complaining witness of those statements in order for her to be aware of them, which is, as I said, a prerequisite for her fear. And the case was not
Okay, we say hypothetically that the comment that the mother testified to that was interpreted as a specific threat against the victim. Say there was evidence that that was communicated to the victim. Wouldn't that be enough without direct testimony from her that she was in fear, given the nature of the statement?
I'm not prepared to concede that. I am prepared to concede that it would be reasonable. That would be enough to fulfill the reasonableness standard, that any fear that she did feel had to be reasonable. However, there's also the requirement that the fear is subjective, that it was actually experienced. And I use fear in the shorthand. The case law says fear is not required. It's really apprehension that physical force will be imminently used against her. So as I said, there is no evidence direct abuse based on those statements because it would require a third-party act, and the case was not submitted to the jury on a theory of violation through third party. The jury were not instructed on that legal theory, and so the conviction cannot be upheld on the basis of that. And even if it could, without violating Mr. DEMELO's due process rights, there was also insufficient evidence that the mother conveyed the statements that Mr. DEMELO made to her daughter. The daughter's only testimony about the calls to her mother was he did not call me, he called my mom. The mother also testified in response to questioning from the Commonwealth that at no point did she ever tell anyone about Mr. DEMELO's statements, save for her husband because he was right there. And the police officer testified about, as well as the mother, about what was in the police report about those calls. And the only thing in there that they testified about was the fact the calls were made. According to the report, the officer was never told that Mr. DEMELO ever threatened the complaining witness or that he ever said that he was outside of her house. So as stated, the Commonwealth cannot defend the conviction on the basis of a legal theory not presented at trial. And this case was not submitted on a theory of violation of a no-contact provision, either directly or through a third party. It was not submitted on a theory of a violation of a stay-away provision, and it was not submitted on a theory of violation of the no-abuse provision through a third party. And we know that it wasn't presented to the jury on that theory because Collier instructs that if it is submitted on that theory, that the jury must be instructed as to an additional essential element of that crime, namely that the defendant intended or at least had a shared intent with the third party to commit the third party act that ultimately violated the order. And the jury here were not instructed as to that element. And the SJC said in Pfeiffer that where the jury are only instructed as to one legal theory, the review for sufficiency is only as to that theory, because to uphold a conviction on the basis that there may have been sufficient evidence on some other legal theory of the case violates fundamental principles of due process. So as I said, this case was only submitted on a theory of direct abuse, not abuse through third party, and there was insufficient evidence of that direct abuse. There was also insufficient evidence of notice of the relevant terms. As the Commonwealth conceded towards the end of trial, Mr. DEMELO had no notice of either the existence of the order or of any of the terms at the time.
Can any inference be drawn from the fact that he clearly was aware of the prior order? He just wasn't aware of the extension until he got on the phone and learned about it. So can any inference be drawn that he must have been aware of the totality of the order because that there was a reference to that order?
No, Your Honor, and I believe that Commonwealth versus Melton controls there, as well as Commonwealth versus Malloy, which says that where a defendant is not served with an annual extension of the order, all that they can be held to know as a result of any prior orders is that there might have been some terms in that order, but those terms expired by operation of law. And under Melton, it was a very similar factual scenario here in terms of the notice element. In that case, the defendant called the victim. She made a statement along the lines of, "Why are you calling me? There's a restraining order." And in that case, the appeals court said that in the light most favorable to the Commonwealth, the only term that provided notice of was that the defendant in that case could not place calls directly to the victim, but not that he could have inferred or should have inferred anything about any other terms or even third-party contact. So as to the calls and statements to the complaining witness's mother here, as we just discussed, the only notice that he had was the complaining witness's statement that you can't call me, there's a restraining order or something to that effect. And so the only term that he had actual notice of was that he could not call the complaining witness. He had no notice that any communications or statements to anybody else, including the complaining witness's mother, might be in violation of the order. If there are no further questions on the sufficiency claim, I'd just like to briefly address the propensity language. So although Mr. DEMELO is entitled to acquittal on the basis of the insufficiency of the evidence, he's also entitled to a new trial because of propensity language that improperly went before the jury. And so in the restraining order, there was language about the firearm surrender order continuing, and that language was that the firearm surrender order continues. The item surrendered under paragraph 12 will not be returned, since doing so would present a likelihood of abuse to the plaintiff. The Commonwealth concedes that it was error for this language to go before the jury. This language improperly implied that Mr. DEMELO had a propensity to abuse the complaining witness.
Isn't there a second problem with that? That it offered another theory of how he might have violated the order if he was supposed to turn over his guns, and there was testimony that by the mother that he was arming himself, and isn't that a more fundamental problem?
Yes, that is another problem of why that language should have been redacted. I agree. But yes, so it improperly implied that he had access to firearms at least previously. It also made it more likely that the jury would take his language seriously as opposed to interpret it as mere hyperbole, as the defense suggested that they should. And contrary to the Commonwealth's assertion, at least one element of the offense did rely solely on the complaining witness's testimony here, and that was the evidence of notice. And in Reddy, which is the controlling case about propensity language in a restraining order, the prejudice there was that it enhanced the credibility of the victim, whose testimony was the sole evidence on the count of assault and battery in that case. And so here, this was the only trial exhibit. Again, the language appeared 4 times. The Commonwealth also directed the jury's attention to the order, telling them that they would have a chance to look at it, as well as all of the terms and conditions. And this language was 4 of those terms. And so all of this together, in the absence of overwhelming evidence that Mr. DEMELO had notice of the relevant terms and committed direct abuse in violation of those terms, created a substantial risk of a miscarriage of justice.
I just have a question about, and it's not clear from the record, did the complaint go before the jury?
No, it did not, Your Honor.
Okay. Thank you.
If there are no questions on any of the other issues in my brief,
Hearing none, thank you very much.
I'll rest
We will
on my
hear
briefs.
from the Commonwealth.
Thank you.
Good morning. May it please the court, Jennifer Cohen for the Commonwealth. The Commonwealth is arguing that in the light most favorable to the Commonwealth, there's sufficient evidence to support the defendant's conviction. The inferences that can be made from the evidence only need to be reasonable and possible, don't need to be inescapable. And here I would argue that
What was the evidence, or if any, that the victim heard the specific comment attributed to the defendant by the mother about the specific threat to the victim?
So, Your Honor, I would say that an inference has to be made based on the evidence, and that evidence being that the officer obviously created a report after he spoke about the incident. The officer couldn't recall having spoken to the victim's mother, and the victim's mother couldn't recall speaking to the officer. However, she did testify that I think it was something to the effect of she might have called while the police were at the home. So I think there is an inference to be made there that if neither...
But the issue isn't did anybody speak to anybody else, it's was the substance of that threat communicated to the victim?
Well, I would say arguably it had to have been if there was no communication between the victim's mother and the police officer. That the only way that the officer could have created the report about the threat.
The report didn't mention the specific threat, correct? It talked about the threat of showing up with guns at the house as opposed to...
I agree, and I think that there's also, if you're inferring that all of this information from the victim's mother came to Officer Cash filtered through the victim, that you have a bit of telephone going on. So I would argue that the mother was the person who actually heard and experienced the call with the defendant, so she was in the best place to recall what she had heard and perhaps what she had said had happened.
No, but the perhaps you just inserted in that sentence is important.
And Your Honor, I think I have to argue this based on an inference. I admit that. There's no direct evidence of this. This is coming from, I think, a reasonable inference.
Wasn't this case tried as a no contact case, where the victim was never asked in any form if she was placed in fear?
Yes, Your Honor. I believe that the ADA trying the case had an honest but mistaken belief that she would be able to prove notice if certain portions of the restraining order came in. So I think where the restraining order redactions weren't finalized until the time that the parties spoke about the motion for required finding, the ADA remained under this assumption that she would be able to prove her case through the initial call and through a no contact violation. And she was the person who limited herself.
But if it's tried ultimately, putting aside the change in theory, but if it's tried ultimately as an abuse case, isn't the lack of evidence that she was placed in fear fatal? Short of a statement that was communicated to her that anyone would have been placed in fear, such as a statement, "I'm going to kill you," isn't it a problem for the Commonwealth?
I agree that it would have been certainly preferable if some other questions had been asked of the victim, but I would argue that the case law is clear that the victim's apprehension of actual fear, the victim doesn't have to testify to being actually fearful. I think what it's a reasonable fear comes from the circumstances of the case.
Doesn't it have to be both actual and reasonable?
I would argue no. I think it does. I'm not sure of the case, Your Honor, but I do believe I've cited a case in my brief which talks about the fact that the victim's fear is irrelevant. The victim's actual fear is irrelevant. It's the reasonableness of the fear given the entirety of the circumstances.
So what would be your best evidence that the defendant had notice that he was to refrain from abusing the victim?
Yes, Your Honor. So obviously the victim communicated to the defendant that there was a restraining order and he was not allowed to contact her because of the restraining order. Now, I would agree that if the Commonwealth had decided that it were going to try to go forward on this stay away portion, that there could be no stay away provision inferred from the victim saying, there's a restraining order, you can't have contact with me. Those are two very different things, and a person wouldn't be required to have no contact and stay away from another person. There's no law that would ever create that in absence of a restraining order. However, my argument is that where the no abuse provision is already, it's speaking to behaviors that are already prohibited under the law. So where the defendant was aware there was a restraining order, he was aware that he wasn't supposed to have contact with the victim, common sense would, I believe, tell us that he wouldn't be able to then try to circumvent the restraining order by engaging in behavior that he couldn't engage in anyhow. This is threatening behavior, so I think it's unlikely that a victim answering a call such as that would say, there's a restraining order and you can't contact me and you also can't abuse me. I'm arguing that that's kind of implied in the restraining order.
It's possible, though, for a restraining order to have a no contact but not a no abuse provision. Is that possible?
Yes, yes.
And I think your argument would kind of do away with the notice requirement for the no abuse provision by sort of saying it's implicit, right?
Perhaps, yes. If there are no further questions.
Just on the housekeeping issue that I forgot to ask defense counsel about, on the dueling motions about the scope of the record, how is the police report properly a part of the SRA?
So, Your Honor, the police report is the document that underlied the application for the complaint. I did have a colleague check with the court, and those documents are all stapled to the complaint. So I would argue that they're documents in the file, and so that they are part of the record. This was also, I raised this on an issue that was not brought to the attention of the judge during the trial, so there was no opportunity during the trial to ever specifically put this in front of the judge. I would-
So just to summarize, tell me if I'm wrong, you're saying it's essentially part of the pleadings of this case. It was not part of the trial record as such.
Yes, Your Honor. And I would say, I understand my sister's motion. I think I would still make the same argument even if I didn't have the police report in there. So I think that if Your Honors didn't consider that as part of the record, my argument would remain the same. And, I'll rest on my brief.
Thank you both
you very
very much. Interesting matter, which is now submitted. We are going to take a brief break of about 15 minutes, and the case of Lawrence v. Somerset School Committee will be next up.
Court is open. Be seated.
Thank you for your indulgence. We are back on the record in Lawrence v. Somerset School Committee, 2023 P. 897. Mr. Phillips.
Good morning. Thank you. Carlin Phillips on behalf of the appellants, Susan Bertrand and TAMMI LAWRENCE. This is a fairly straightforward case where nurses working for a town were mandated by their town school committees to work through their lunch break. The union grieved it. They went through a full arbitration process, and the arbitrator ruled that they violated the CBA by forcing the nurses to remain in their working during the lunch breaks, and awarded what he called asked to make them whole as far as damages with no interest. So after that, the school committee issued back wage checks to all of the nurses that were affected, including Ms. Bertrand and Ms. Lawrence, and taxes, payroll taxes were taken out of those checks. And that's significant because there's some discussion in the ruling that they weren't awarded wages, so to speak, and they did issue them a W-2 check. And with that backdrop, at summary judgment, the defendant submitted.
Before we get to summary judgment, can you just help me understand the relationship between this action and the grievance filed by the union? Because there was the grievance.
Yes.
There was an arbitrator's award saying, make them whole.
Yes.
And then there was, as I understand it, a settlement. And so how does your action relate to that? Is it that this violates the settlement? Is it that the settlement wasn't enough?
How it relates, so when you have a CBA, the language of the CBA is always resolved in arbitration. Right. So when you have a concurrent Wage Act claim with the CBA, you can bring your Wage Act claim, but the issue regarding interpretation always has to be done in the context of a union arbitration. So you can bring your Wage Act claim and they run parallel. So the ruling on the CBA affects their right of whether they earned wages under the Wage Act. So they can run parallel, but you have to exhaust your union remedies first, and so that decision becomes important.
I understand that, but your client's side won, and the
Yes.
net effect was a settlement to saying, make them whole. And you're saying, in part, we weren't made whole.
Okay, sure.
And so how does that relate back to the settlement and whether or not this should have gone back to the arbitrator about whether or not they had made everyone whole?
I understand. So when the union decided to resolve the issue with the school committee, the union has the power under the case law to make a decision for the collective members. It doesn't always have to make the exact decision an individual member, whether they like it or dislike it. And so there was a resolution, a vote by the union to resolve the issue with the school committee. We expressed, that's why we wrote a letter basically saying we're not waiving any of our Wage Act rights. There was no settlement signed, there was no waiver, there was no release. There was just a check issued to the named plaintiffs in this case and to the other nurses. So that resolved that end of it, which was the arbitration end. And then the Wage Act claims, which were not released or waived in any manner, continued. So the back wages were paid while the Wage Act claims were pending as part of the union arbitration. So they would be entitled to 3 times their wages plus the statutory interest of the Wage Act. So while they're parallel, nothing was waived in the process.
But what if we disagreed with what the arbitrator said? Are we bound by that?
It's a very interesting question because I think to agree the trial court misinterpreted some of what the arbitration decision said. I would say you're bound by the language in the arbitration agreement with respect to the interpretation of the CBA.
With respect to the interpretation of?
Of the CBA and the language in the CBA.
The arbitrator's decision said that the school committee has to make the nurses whole for those lunch periods that the school committee required them to remain in the schools during their lunch periods, right? So they're getting paid for the fact that they have to stay, eat lunch in the school, can't go out. But your argument seems to be fundamentally different. You're saying they weren't paid for those periods, right? Is that sort of, that there were these lunch periods and they weren't compensated for those periods at all, regardless of whether they were on premises or off premises, is that right?
Not really. They weren't compensated until the union arbitration decision came out. Then their back wages for those periods were paid based on that agreement the school committee reached with the union, okay? So they were paid.
But they're being paid for the fact that they had to stay on the school, right?
Had to work.
Not
The
for
half an hour they had to work.
not work. They lost some of their rights by having to eat lunch on the premises, and there was some payment that was made to make them whole for that deprivation. Isn't that correct? That was what happened with the arbitrator?
I would say wages were paid, back wages were paid, because they got a payroll W-2 tax. Payroll taxes taken out. They were paid, in other words, they weren't paid an inconvenience damage. They didn't get a 1099. They weren't paid for any other type of damage. The only damage they got paid was back wages.
Well, was there a finding that they weren't paid for these periods by the arbitrator? Or the arbitrator, I mean, just the order says, make them whole for the lunch periods, which the school committee required them to remain in their assigned schools during the lunch periods, retroactive, right?
Yes.
So that doesn't seem to be a finding, well, they weren't paid for those periods. It's just sort of they lost some of their liberty to go outside the school. And so I'm just trying, I know you're categorizing as a back wage check, but they may just be the way the settlement was paid out. And there's no finding that they weren't actually paid for those periods.
Well, there's no finding.
Okay.
They were issued wage checks. You only issue wage checks when you're being paid a wage. Any other damage in a case is a 1099 damage.
Okay.
They paid them, and they calculated the number of lunch periods they missed, and they accumulated those, and they multiplied it by a nurse rate, and they came to that wage and issued those wage checks.
Okay, so let's get to the evidence that you have in this case that they weren't paid for certain lunch periods.
Well, they weren't paid for any of the lunch periods up until the time of the union arbitration agreement. Then after that period, they did change their practice. Any reference in our brief that they didn't change their practice is a misstatement. They did. So the stopgap is the date of the union arbitration agreement, January 18, 2020. So we're talking about the period of time when the new contract went into place up to January 18, 2020. They were paid portion of their wages under the settlement, but they're entitled to double or triple their wages under the Wage Act plus 12% statutory interest.
What's your evidence that they weren't paid for those periods? What's the payroll evidence? I mean, is that...
Payroll evidence is inconclusive. We can talk about the payroll evidence because it doesn't really show much at all. If you look at the payroll evidence, because there's just a 70-hour, if you look at the payroll records, for example, go to the record appendix 186 to 203, or 433 to 499, or 529 to 446, there's zeros.
Yeah, those are pre, I think, September 2015.
Right.
And so everything, the relevant period here is after September 2015.
Right.
So the evidence that you have that they actually weren't paid is just sort of the nurses' statements themselves that they weren't.
No, I think it's
Is there anything more than that?
the language of the CBA. They were only required to be paid work 6 hours and 20 minutes. That's what the arbitrator ruled, and that's why they issue damages. Under that, the language of the CBA supports that they were not paid. It's a fiction that they were not paid. They negotiated this CBA. For example, if you have a contract and you break the terms of the contract, make someone work an extra half hour before, after the day, or in the middle of the day, don't you have damages because you're required to work beyond the bounds of your contract? This is just an employment contract like any other employment contract. They were required to work an extra half hour a day under an employment contract with an arbitrator found was a violation of the agreement. So that extra half hour of working,
But that's not what the arbitrator found. The arbitrator found that they were wrongly required to remain at their schools during the lunch break, but not that they weren't paid for it. There's no finding by the arbitrator. This is why I get my initial question. There's no finding by the arbitrator that they weren't paid for these periods.
I wish the language was better. Yes, it's unartful is the way it's described. It says make whole, but what does that even mean? That would be wages to make whole. And it says, and the indication that I do not order interest. Well, it's a monetary award that he's factoring in. He's not awarding interest, right? The only monetary award they received was a paycheck, a W-2 payroll check.
I'm just trying to know what, the issue now is, did you present enough evidence to establish a genuine issue of material fact as to whether or not their nurses were not paid for these periods?
Yes.
And I don't understand where the evidence comes from the arbitration proceeding itself, because that seems to be a slightly different issue. The payroll records don't establish that for the relevant period. So you're just relying on the statements by the nurses themselves, which are just sort of assertions, but not really anything more than that.
The payroll records, if they've done wrong, how do I show the absence of payment in the payroll records? They didn't pay them for time. They didn't capture it in their payroll. They should have increased their pay. In theory, you're asking them to show the absence of evidence in a document created by the defendants when they have no affidavit explaining why there's zeros, why there's 70s, and why in a whole bunch of other entries.
Well, these are salaried employees, though, so it's not like they're punching a clock and you're going to be able to tell, okay, you were here on this day, you didn't get paid, or you were here and you did get paid.
I think very loosely using the word salaried employee. And I compare it to like independent contractor. I see a lot of times people say you're an independent contractor. Well, really, are you? If we peel it back, are they salaried employees? The payroll records are replete with instances where they get paid 3, 4, 5, 1, 4 extra hours at a nurse rate. Anytime they work beyond the 6 hours and 20 minutes, they had to get permission and they had to be paid.
Well, that's just
so they're hybrid employees. They're hybrid.
Well, that's
It's a
just for the
hybrid
purpose
situation.
of calculating, putting a dollar value on their time, but it doesn't mean that, for example, it doesn't mean that come lunchtime, they have to run down to a time clock room and punch out for that half hour they're on lunch. I mean, they get to take the lunch when their schedule permits and so forth, and
But that's only one indicia of a salaried employee. For example, you can't call them at night. They don't have to respond to emails. They don't do anything before or after work. They have no responsibilities other than that 6 hours and 20 minutes a day. A salaried employee, typically, in the use of the general term of salaried employees, has a lot more responsibilities when they're a salaried employee. That's why you put them on as a salaried employee. So you have the luxury of getting hold of them night and day, weekends and what have you. This is kind of a hybrid situation where you have a contract defining exactly the number of hours you work.
let me ask you, how are the nurses different than the teachers? Because as I read the provision here in the CBA, it almost seems to me like the nurses do better than the teachers. Because for the nurses, it says that should their break time or their lunchtime be interrupted, they are entitled to time of equivalent length that will be made up later. So to me, that says that they get comp time. So for example, if you miss your lunch because you have to take care of a sick child, well, you can take that lunch period later in the day. You can get your uninterrupted period later in the day. Regular teachers don't have that in their provision, so if someone comes to a teacher at lunchtime and needs extra help on something, and that teacher gives that student extra help, well, that teacher better be eating his or her sandwich at the time they're giving that extra help, because they're not going to get any more time for that. They don't get comp time. So it seems like the nurses are in a better position.
Under the new CBA, I assume you're referencing the new CBA, because for years, the problem was the nurses were second citizens to the teachers.
This is the latest CBA that I'm referencing, right?
I mean, how all that plays out in the comp time, I know that whenever they do extra time, whether it be the teachers or the nurses, anything beyond their regular time, they get paid.
Well, this goes to my initial question of, are we bound by what the arbitrator determined? Because it seemed to me it was a pretty thin decision, just summarizing the positions of both sides, and then, okay, here's my conclusion. There was really no analysis, because as I read it, it seems like the nurses were compensated. They were just compensated with additional uninterrupted time later in the day if they wanted to take it.
Okay.
So they didn't go without compensation. They did have compensation.
I disagree. I mean, they wouldn't have gotten a monetary settlement in the form of a W-2 wage check if they weren't unpaid for hours worked. That's why you get wage checks. W-2 payroll taxes taken out. That's paying a wage. That's how it's done. So and to say they weren't paid belies the whole circumstances leading up to this, which is it's in the arbitration agreement. This dispute, these nurses fought and fought and fought to get the right equal to the teachers, and finally did, but still had a clause where only if the law allows them to stay. And they defeat that, and then they don't get their wages back. I just don't see how they don't have Wage Act rights because they earned those wages because they work that time.
Counsel, your time is up, but I want to give you an opportunity to respond to the statute of limitations argument
Yeah.
that the defendants have raised, because unless I missed it, I don't see a reply brief responding to it.
Yeah, I don't have the math is the math as to when we filed it, and it goes back 3 years. I don't disagree with that. The second case was filed much later than the first case. So it goes from the filing date back 3 years.
Okay.
For the purpose of the
Can I
wage
ask one more question?
Sure, of course.
So Judge Hodgens raised, what if the nurses are salaried employees? But let's assume they're not, and they're just getting paid on an hourly basis. The payrolls records show 70 hours are paid to each of them for a 35-hour work week. The CBA provides that nurses can't work more than 6 hours, 50 minutes per day. So if you do the math, it seems like the 70 hours is covering more than they're supposed to be working. Why isn't that enough to?
Because that's not the standard. They're obligated to work under the contract 6 hours and 20 minutes. The school day is 6 hours and 50 minutes. The bank's open 9 to 6. You only work 9 to 4. They don't have to work the entire school day. So the court conflated, the trial court judge conflated school day with their obligation of how much they have to work during that school day. The two are not the same. So by saying they work at 650 and put 70 on their hours, that's not even consistent with the CBA. They're only required to work 6 hours and 20 minutes. So even the 70 is inaccurate on its face.
But even to the extent it's that inaccurate, they're getting paid more than they're supposed to be working, right? So that's the problem, right?
We don't even know why that 70 is on there. There's no affidavit saying the record-keeping process. We see 0, then we see 70. Why? Why is that? Don't I get to ask that witness on the trial, why are you doing that? Why are there all these 1s and 3s and 4s? Why are there 0s? Why is it now 70? Those are all disputes of fact. I should be able to get a witness on the stand and ask that witness those questions. And then we hear it. We hear the testimony, and then I get to ask about the CBA to that witness. How many, I get a series of questions I have for their witness, which they claim these are undisputed facts. They're not undisputed. There's a myriad number of disputed facts here.
Counsel, we're going to have to leave it there. We will hear from the school committee.
Good afternoon, Your Honors. May it please the Court. My name is Joe Proctor, and I'm here on behalf of the defendants, the Somerset School Committee, and the Town of Somerset. Now, briefly, before I get into the gist of my argument here, I would like to address the confusion over the arbitration proceedings. The arbitration proceedings were an entirely separate issue than the one that has been raised here by the plaintiffs. Those arbitration proceedings concerned whether or not, pursuant to the contract language, which was changed, school nurses were allowed to leave their buildings during their meal breaks. Previously, it said they had to remain in their assigned schools. After negotiations, it was changed. They had to remain to the extent required by law. There is no law requiring school nurses to
Let me ask you about that, because you don't have to look very far to find some law, and I was surprised that none was mentioned by the town. So, for example, just in Code of Mass Regulations 105 CMR 210.004, subparagraph 3, B3, it says a school nurse shall be on duty in the school system while prescription medications are being administered by designated unlicensed school personnel and available by telephone should consultation be required. That's just one example that just jumps right out when you just look it up. So there do seem to be regulations that require nurses to be present in the school at certain periods. So that language in the CBA doesn't seem inappropriate, and yet the arbitrator seemed to hang his hat on that as well. That language shouldn't have been in there, so therefore I find in favor of the nurses. That's why I'm wondering, are we bound by what the arbitrator has said? Because it seems like it's a pretty questionable decision.
I suppose what I would say to that is I don't think it quite much matters in terms of the Wage Act claim that the plaintiffs are bringing here, what the arbitrator said. I agree with you that I wasn't the one who conducted the arbitration proceedings. I don't know what laws or regulations were raised and the arbitrator considered in terms of interpreting that language. Perhaps there are regulations out there, like you just stated, that would have supported the town's position in that arbitration. However, the arbitrator did not find that the school nurses were not paid for their meal breaks. That was not the issue before him. That is not mentioned in his decision, sparse as it may be. It was
So
a separate issue.
what were they paid for in the settlement, in the ultimate resolution? How were they made whole? What were they made whole for?
Well, I suppose you can't go back in time and give them back the ability to leave their schools. So in terms of making them whole, the union and the town negotiated a resolution which was to issue them payments based on their workday, which they used to.
But what does that mean? They worked the half hour, but they worked it from the premises when they, according to the decision, should have been able to leave if they wanted to. So is that, I mean, Mr. Phillips makes a point where they're paid back wage checks, but are they being paid extra wage? I don't quite understand what the nature of that settlement was. How would you characterize the payments that were made to make them whole?
I would characterize it as a make-whole remedy in terms of something that could not be made whole in any other way beyond a monetary payment. I don't see how they would have been able to make these nurses whole for this time that they were deprived of the right to leave their schools and go out to lunch or run an errand or something like that.
But were they paid one time and not the 3 times under the Wage Act, or is there a dispute as to the amount of the one time?
Well, I guess I would circle back to they were not considering whether or not they weren't paid wages. That was not the issue at the arbitrations. They were just issued that one payment in settlement of the
But
arbitration.
what does the make whole mean if you're looking retrospectively to compensate them for a time that they were doing something they weren't required to do?
Not entirely sure on that one, Your Honor, frankly. That was negotiated between the town and the union. I wasn't present for those negotiations, and that's not in the record here before us. So. But I guess circling back to my main argument here is that the defendants are entitled to summary judgment on the plaintiff's Wage Act claim because their undisputed material record indicates that they always received pay for their entire regular workday. Now, their entire regular workday, as the CBA states, the school day is 6 hours, 50 minutes long. That equates to the regular workday of the school nurses. They don't allege that they had to work more than 6 hours, 50 minutes. In fact, they allege that they should have had to work 30 minutes less than that. However, if you look at the payroll records for the applicable period of time, which is that dated back 3 years from when they filed their original complaint, it shows that every biweekly pay period, all of the plaintiffs received an amount of 70 hours of pay. And if you break that down, it'd be 35 hours a week or 7 hours per day if you work 5 days, which neatly covers the 6 hour and 50 minutes they had to work. Therefore, there is no period of time for which the plaintiffs performed work and they were not compensated by the defendants, which is fatal to a Wage Act claim.
Are the nurses, you argue that they're salaried employees.
Yes.
Is that correct? What's your evidence for that they're salaried?
My evidence for that is that when they were initially hired, they were provided correspondence saying you'll be paid an annual salary of so much. They received similar correspondences saying you got a salary increase of this much over the course of the year. There is no requirement they punch in and out of work for
That evidence is in the record, that the nature, that evidence you're stating is in the record?
The
That they were
initial
salaried employees?
Yes.
Okay.
I have the email, or the letters from the schools to them on their date of hire saying you were paid initial salary of such amount.
Then why do the paychecks list hours?
I'm not sure entirely of why the paychecks list hours. I believe it is just to indicate that that is the total amount of time they had spent working as their regular workday, because, as my brother mentioned, they are able to perform additional duties beyond their regular workday, and they receive different amounts for that. So if they go work an extra hour performing some other kind of function covered by their collective bargaining agreements, they can get money above and beyond what their regular salary compensation is.
So under the committee's theory, is this a case where the plaintiffs simply did not produce the evidence, or, in your view, could not produce the evidence?
Could not, Your Honor, could not. Our position is that we acknowledge the plaintiffs here, the school nurses, were, for the time periods at issue, on call in their assigned schools, and thus they were entitled to compensation for that 30-minute meal break time because they had to be there to perform duties. They weren't allowed to leave. Our position is that they were paid for all of that time, and that is what the payroll records show and the Superior Court correctly found. And having established that, it becomes the plaintiff's burden to submit some sort of evidence showing that this is not the case.
So what, if you're correct, what, going back to an earlier question, to the extent the committee cut checks, what were those checks based on?
My understanding is that
If they owed no money to make them whole, why were they writing checks, and for how much?
they had violated the unit members' rights under the collective bargaining agreement, and they had to find some way of making them whole. So they went into negotiations with the union, and that is what the two sides agreed would satisfy the arbitrator's award. That is my understanding.
Well, that's where, okay, and so this is kind of the heart of it. So by agreement, the union and the town came up with the multiplier or quotient, I guess, 6.83.
Yes.
And the teachers, the nurses are saying that that's the wrong quotient, that it should be 6.33.
Mm-hmm.
That's what it comes down to. So where did you get that number of 6.83? What's that based on?
6.83 corresponds to a 6-hour and 50-minute regular workday.
Okay, but why? So why was that picked as opposed to the 6-hour and 20-minute day?
The 6-hour and 20-minute day would suggest that they weren't being paid for their meal breaks, which they always were being paid for their meal breaks, hence why they used the 683 rather than the 633, I believe it was.
Okay.
And therein is another important, rather telling aspect of this case, I believe, is that these complaints by the plaintiffs that they have not received pay for their meal breaks, this is not the first time these have been raised. This is the first time in a court of law they have. But they have made these complaints to their union in the past, and email records in the record appendix will show that. And it is telling that the union, who is charged with interpreting the collective bargaining agreements and protecting their members' rights under that agreement, has repeatedly rebuffed the notion that the school nurses are not paid for their meal breaks. And they haven't simply declined to grieve that issue on their behalf. No, rather they have expressly told them, you are paid for your meal breaks. You are salaried employees. The same is true for the teachers. They are salaried employees. We are all paid for our meal breaks. It is true that the teachers might be able to get extra money by performing lunch duties, but one of the emails from a union leadership member even says this number they can receive as additional pay for these duties is low, in acknowledgement of the fact that we are already being paid for our lunch breaks. And I think that is the heart of this issue here, is that the plaintiffs cannot maintain a Wage Act claim where they are unable to show that they did not receive wages for the work they performed. The defendants do not dispute that they were performing compensable work by being on call in their assigned schools. Rather, the defendant simply paid them for all of this time. And then, so the burden was on the plaintiffs to have to show something, and all they have submitted is their personal opinions and subjective feelings as represented in the amended complaint and in the affidavits they submitted. They cite to no sufficient evidence to rebut the payroll records, the arbitration award, the communications from the union leadership. They have presented nothing that can overcome that evidence, and that is why the Superior Court correctly granted the defendants summary judgment on this Wage Act claim. And I note that there was references to the earlier portions of the records, which may list zeros rather than the 70, which we are using as the basis for the 70-35-7 calculus there. Those portions of the records are largely immaterial. They predate the earliest date of the plaintiff's claims. As my brother acknowledged, the statute of limitations bars the claims before a certain date. For all of the time at issue here, the payroll records are unambiguous. They say 70 hours in terms of regular compensation.
Well, even setting aside the statute of limitations argument, the relevant period has to be the 2017 to 2020 CBA. Is that correct, or is it prior agreements as well?
I think it goes back even before the CBA language changed. I believe the full scope of the timeline we're dealing with here is June 13th, 2016 to January 18th, 2020.
Okay.
June 13th, 2016, representing the look back using the statute of limitations, and the latter date, the 18th of January 2020, being the date of the arbitrator's decision, upon which they were no longer required to stay in their schools.
So if what you're saying is true, that the nurses have no Wage Act claim because they were in fact compensated as a result of this agreement that was reached following the arbitration.
I would jump in there. I would not say that that is why they were compensated. The defense position is they have always been compensated regardless of that decision. That was a separate matter.
Understood. Okay. If all that's correct, then, and if the nurses are still not satisfied that they were paid the wage that they believe was due, what then is their remedy?
I didn't brief this here at the appeals court, Your Honor, but I will note that in the summary judgment briefing we filed, we actually say that this issue is more appropriately raised with their bargaining representation. If they believe that they are not receiving enough money for the duties they're performing, that is something they should bring up with their union representation to then press on their behalf. And if they feel their union representation is not doing a good enough job there, they have the right to file charges against them. Their dispute lies with the union, not with the defendants here. The defendants have always paid them for their compensable time. If they think they should get more money because they're performing more than the teachers or something along those lines, that's not the issue here before us today. We are dealing with a Wage Act claim.
I think we get it, counsel.
All right.
You have a minute and 44 seconds if you'd like.
I guess I could briefly stick on the notion that salaried employees, I believe it is a fair inference to say that in the absence of any evidence to the contrary, it's a common sense kind of point that you would assume that a salary is apportioned evenly over the course of their working day, such that it is inclusive of their meal breaks. Here, there is no indication that defendants ever deducted money from for meal breaks. There's nothing in the record to that effect. Therefore, I think there's no reason why we should assume that a salaried employee would not be considered to have a paid meal break because they are salaried. I acknowledge there's no case law here in Massachusetts in that effect. In fact, my research reveals there's a dearth of case law kind of across the country, aside from a handful of cases out of the appeals courts in California and the Supreme Court of Alabama, taking that position that you apportion a salaried employee's salary over their regular working day. But I do not believe—
Those are all workman comp cases, right?
They are workman comp cases, and I do not believe that they are necessary for the defendants to prevail here today. And with that, if there are no further questions, I will rest on my brief.
Counsel, thank you very much. Thank you both very much. The case is submitted. Our next and final case of the morning is 2023 P1221, ERHARTIC versus ERHARTIC. And my apologies if I have mispronounced any names. Counsel.
Good afternoon. May it please the court, Lynn Eisenman on behalf of the mother, ALYSSA ERHARTIC. Your Honors, the crux of this case really is that there is a disconnect between the judge's subsidiary findings and her ultimate conclusions about legal and physical custody. So at trial, we had multiple witnesses who testified about the inability of the parties to communicate and that was attributable to statements that the father made and actions that he took, as well as concerns about Dad's interactions with particularly the child's providers. And yet, in spite of those findings, and the judge made specific findings about those communications and actions, and yet in spite of those findings, she nevertheless made the ultimate conclusion to continue joint legal and physical custody with both parties. So first of all, the judge found that there was no substantial, material and substantial change of circumstances since the time of the parties' divorce. However, that is in direct contradiction of her earlier finding in number 47, where she says, quote, what emerged in the years after the parties' divorce, and then she goes on to talk about the conflict in the parties' relationship and persistent pattern on the part of father, using the terms rude, aggressive, uncooperative with both mother and third-party professionals. So that is the change of circumstances, and she made a specific finding about that. So the later conclusion that there was no change was error. And with respect to the second—
how much of a change is it really? I mean, the parties have divorced. So it really shouldn't be surprising that there may be some animosity, maybe some lingering animosity between the parties. So the fact that there's still that animosity or some behavior that might be characterized as, not helpful or however the judge said it, that's really no big change, is it?
So certainly there's going to be some animosity, right? They got divorced. They did reach an agreement at the time of the divorce. They had a separation agreement. So there was at least a meeting of the minds at that time. But this really became extreme. And when you have a guardian ad litem who's using the word toxic to describe their relationship, we have over 300 pages of emails and text messages between the parties where it's nonstop attacking and being aggressive and disagreement. And I think one of the most important findings is that actually harmed the child. When the judge talks about, at best it was, disrespectful to mother but at worst that it was not in the child's best interest and actually caused him harm because there was a delay in getting him some services that he needed. So I think that's the change of circumstances. And yes, they didn't see eye to eye at the very beginning, but that was primarily, I think, mostly about the child's schooling and where he was going to be attending school once he entered kindergarten and kind of how the relationship was breaking up. But then it got worse from there.
How do you address the fact that the judge saw the father as having made progress? And, viewed from 20,000 feet, the judge appears to be saying, with the father making progress, we're just not at the breaking point yet. I'm not going to change custody. Why isn't that the essence of a discretionary call to which appellate courts defer to the trial judge?
Sure. So a couple of thoughts on that. One, it's self-serving testimony, and I do understand that the judge has the ability to credit witnesses. It was his testimony that at trial that he had begun seeing a therapist several months prior to the first date of trial and that he thought he was improving and really helping himself. That was a very short period of time, given the long-standing, we had about 6 years worth of conflict from the time of the parties' divorce up until the time where he started therapy. And we had no corroboration of his belief that he was improving. So simple way to address that would have been to have the guardian ad litem talk to his providers, the therapist and the psychiatrist, get information about when he started treating, how often he treated, what kind of progress he was making. And he doesn't have to necessarily waive his privilege in order to do that, but doesn't have to get into the conversations that he necessarily had, but some way to verify from the outside what he was actually, the services that he was engaged in and whether he was making progress or not.
Right, but the judge did find that the father was undergoing therapy and making efforts in this regard, right? I mean, that's so it's hard to say it was self-serving if the judge found it. I mean, I think the judge's findings and your brief raises a lot of really serious concerns, and if under the abuse of discretion standard, had the judge changed the current parenting plan, I think it would be easy to uphold that. It's the question of when the judge doesn't make a change to the current plan and also defers to the guardian ad litem's recommendations, who I agree was very, very critical of the father, but also found that the child has done well under the current parenting plan and transitions easily between the homes and overall is happy and well adjusted. It seems tricky for this court to kind of second guess the judge's determination on those issues, at least at this point, and recognizing that circumstances may well change in the next upcoming months that would require a new assessment, a new motion for modification. But I think that's a problem of particularly deferring to the guardian ad litem's judgment here, who does seem very critical of the father, yet nevertheless recommends that the current parenting plan stay in place.
Right, so I think there's two pieces to the GAL's recommendations. So we have he was charged with investigating and making recommendations to the court about not only legal custody, but physical custody. Certainly on the physical custody piece, he did not recommend any change. The judge is still not bound by that, and I think she's got a lot of concerning findings about father's behavior in requiring 2 sets of clothes, 2 cell phones, 2 separate lives of this child when he's with the father versus the mother. So the judge is not bound by the GAL's recommendations on that. She has to make her own independent determination, and she's got internal findings in her subsidiary findings of fact that say it's not in this child's best interest for him to have 2 lives with 2 parents. And that it's causing him undue stress and worry. On the legal custody piece, the GAL did not make a recommendation on legal custody, unfortunately. He had a very in-depth investigation, and it was long, and it was, as you pointed out, critical of Dad. But there was testimony at trial by first the child's therapist that Dad was interfering with the child's therapy. And then the GAL testified that had he known that one parent was trying to influence the child's therapeutic work, that would have changed his recommendation on joint legal custody. So he essentially deferred to the judge in the first instance of when he filed his report, but then at trial said, had I known that this is really what was going on with the therapist, because unfortunately the therapist refused to talk to him in any great depth about the work that she was doing with the child, that he would have made a different recommendation.
The judge did find that the father signed off on the IEP and was adhering to that, right? I mean,
Correct.
There's a lot of serious concerns about the initial diagnosis and the resistance to that, and generally the hostile treatment with which the father has treated the professionals.
Correct.
But if the IEP is kind of one of the key factors in terms of the child's ongoing condition, the evidence is that the father's respecting that, at least for now. Is that correct?
So I think, right, and the judge did make a finding that eventually the parties are pretty much able to get to an agreement. But I think even the judge's findings voice her concerns with how long some of these things take to reach an agreement, and the fact that there has to be this back and forth, and things get drawn out. And I go back to the finding of, causing the child harm because services are delayed. And ultimately, did the child get his IEP? Yes, he did. But had it happened sooner, or had there not been the pushback with the neuropsych evaluation and all of these things? And so the end result perhaps is the same, yes, but it's getting to that point, which is the extreme difficulty in this case.
But the bottom line, though, is that the parents are able to communicate and make decisions, right? In other words, it might be a painful process to get there, and it might take some time to get there, but ultimately there is communication and there are decisions being made. So doesn't that support the judge's decision to leave things as they are?
So I guess the problem is that the process is painful, and it shouldn't have to be that way.
Painful for the parties is what I'm referring to.
Correct.
It is
Yes.
painful, sure.
Right. But I think I go back to, and I don't mean to harp on it, but the judge's finding about how services for this child are delayed. And so, yes, are they able to reach an agreement? Yes, but they have a lot of professionals working with them too. So they have to go to a parent coordinator. They were referred to a high conflict parenting class, which I think is very telling just in its name. All of these things that do cost money, number one, but also I think indicate the level of acrimony between them, and how much strife there is between them back and forth, and the work that it takes to get to that ultimate decision that they're trying to reach. And so that's why I think having sole legal custody was appropriate, because it shouldn't have to be that painful and take that many services in place to try to reach a decision that's in the child's best interest.
Why isn't that an argument for the next complaint for modification as opposed to an argument to an appellate court that there was an abuse of discretion here?
Because I think I would get pushback that there's been no change of circumstances going forward. Because if there's this level of, and to use the judge's word, rancor at this point, that's only going to continue. I don't know that it's necessarily going to get particularly worse because it was pretty bad. And so the threshold is there a change of circumstances? And so if the acrimony is still there, I'm not sure that it's the subject of a complaint for modification. I guess it could take a different form, certainly, and anything could happen, but at least on these communications and the father's ability or inability to work with providers.
I mean, I guess if you look at the snapshot of where we are now, where she ended up, it seemed to be a lot of problematic behavior, but the father's in therapy, he's trying to do better, he's complying with the professionals in a way that he hadn't been before. If that were to deteriorate, that would seem to me another basis for a motion to modify. The status quo is assuming a lot about continued and improved behavior on behalf of the father. And if that weren't, that's how I read the record now. So it seems like there would be a window to sort of go back and say, this is not working in the way you thought it might.
Right, and there certainly could be. Sure, if things deteriorate. I guess the other piece of that, to go back to father's recent positive gains that he's alleging, we had a GAL report in October of 2021. It took about a year for him to get engaged in therapy, and trial was coming up. So, people will do and engage in services that they think are necessary. But again, that's another instance of delay, even for services for himself. We had a GAL recommending that he be engaged in therapy, and he didn't take that action until just a couple months prior to trial. And again, to go back to the judge's own words within the subsidiary findings, and it's not like she didn't credit, either the GAL's report or the emails and text messages that were in evidence. She characterized them as abusive and hostile, and those are the findings that we're left with, but we're left with a totally different.
Why doesn't that equally cut against you in the sense that the judge recognized the problems here and then in the end said, despite the problems with the father making progress, I'm not going to pull the trigger yet?
Because I think that the problems were so pervasive, and it was every email there was instances of a problem, and it was long-standing, and the GAL recognized it as such, and I think and the judge did as well. And just to address my requested relief, I am asking for an order or a direction to the trial court to enter a judgment for sole legal and physical custody. And I'm just asking that because this case has been pending for almost 4 years at this point, which is about a third of this child's life. So in an effort to not draw that out any further, that's the reason for that request. And if there are no further questions, I thank the panel very much.
Counsel, thank you very much. We'll hear from the father.
Good afternoon. May it please the court, Dana Curhan for the father. The trial court was not compelled, as a matter of fact or law, to accept the mother's arguments. And the
trial court does appear to have accepted many of the factual arguments.
I think the trial court accepts some of them, not all of them. And the court also accepts some, but not all of the recommendations of the GAL. When you look at the emails, and there are dozens of them in the record appendix, most of them are not problematic. Even the ones that are problematic, I I'm not sure if they can fairly be characterized as hostile, but, you know, compared to a lot of cases I've handled before this court. But in any event, whatever, the judge actually specifically found that there was a reason for the father's, for him having a problem with having trust issues and things like that. The judge specifically found that the mother has been trying to take custody away from the father since the beginning. I think the first motion for modification was filed 5 months after the divorce became final. And so, you know, there's obviously a pretty good reason for a lack of trust. And, you know, the therapist was the mother's former therapist, and so he had issues with that. You know, right now, as of January 2022, the son has a new therapist, and that seems to be working out. The father, again, as this court has indicated, is in therapy. The parties are now using our family wizard, and communications have improved. So, you know, I think when we're looking at has there been a material change of circumstances, can these parties not get along?
You know, the judge found, like, okay, maybe they work things out eventually, but it's really, really arduous and hostile and difficult for them to make basic decisions, particularly about the child situation. And that's sort of, I think that, I really take the mother's point that kind of relationship, making things that should be relatively easy hard because of the relationship, the interactions. You know, I think that really does add up after a while. And the other concern is just, it seems undisputed that the father has taken very hostile positions towards professionals who are trying to assist the child and reacting badly to diagnoses and things like that. That's really problematic. And I think those are kind of concerns that my reading of the judge's decision is that these need to be addressed and need to be improved because this cannot go on. Would you agree with that?
I think the judge did address that, and he said, you know, that the problem was not necessarily that he objected to services and therefore they were denied, it's just that they were delayed, and that he is working on that now, and that he's made progress, and he's been respectful and contrite and is trying to work on things. Now, the judge made that finding, and I don't think there's any basis for saying that she abused her discretion or that those findings were not supported as a matter of law. I would also dispute that most of the communications were hostile and were not helpful.
And that was the guardian ad litem's finding, that the father's behavior is hostile and abusive, frequently attacks the mother via texts and emails, engages in black and white thinking, takes the most negative possible view of things. Those were the findings of the guardian that seemed to be credited by the judge.
But when you look at those, the texts and the emails in the record appendix, you'll see about 90% of them are just fine. This is what he ate today. This is what he wore. This is what we did. And they are completely innocuous. They are fine. They are probably better than you're going to get in most cases involving divorced parents. There are some issues that came up during COVID where they had disputes, they had disagreements on how things should be handled. There were some issues regarding professionals at school regarding his diagnosis, but I think those issues have been resolved. And I think we have to give the judge the benefit of the doubt here, especially where there is testimony and evidence supporting the judge's ultimate conclusion. So, you know, that sort of, my sister's argument is a perfectly fine argument that is appropriate to raise in the trial court, not necessarily here. The question is different. Did the judge commit an error of law? And I don't think so. I don't see anything. Did the judge abuse her discretion? And the abuse of discretion would be clear error, making a finding that wasn't supported by testimony or other evidence, and I don't think you can say that either. If we want to make a rule that says whenever there's any kind of conflict, you have to give custody to one or the other, there are going to be thousands of divorce cases where one parent goes in and says, hey, you know, this is too hard. We can't do this. And, you know, the reality is, if on the spectrum of things, when you look at divorce cases and you look at, you know, child custody issues, these parents have done pretty well.
Well, that's not my read of what the judge's decision is. This is not going great, at least in some respects, but I am going to allow the father to pursue his course of improvement, pursue therapy, and do better in the future. That's how I read the decision. It's it's not like this is good enough for a divorced couple. There are serious problems here, but I'm hopeful that we're moving in the right direction.
I think I would read the judge's decision as saying there are times when this has not gone well. And there are probably more times than there should be. But I see an improving trend. So in the year or two prior to trial, again, therapy using our family wizard, the son has a new therapist, and things seem to be going better. And, you know, of course, as he gets older, he is about 12 and a half now, things are probably going to go, a lot of the things that are controversies now are probably not going to be controversies.
Well, let me ask you this, because it seems to me that it is hard for the mother to get around the judge's conclusion that the child has done well under the current parenting plan, is overall happy and well-adjusted. But what causes me concern is her next line, where it's written, father's positions can cause him undue stress and worry. Now, how does that factor in as far as the best interests of the child?
Well, I think the judge also looked at other factors, which is, for example, as the GAL found that the child is very attached to both parents. They are both loving and capable parents. They work in his best interests, except for probably that line. There's probably occasions when the father doesn't. You know, I think you have to look at the big picture. That's one factor. But the other factor is the child would be upset if you said, okay, I'm going to make a change in custody. And that would not necessarily be in the child's best interest. That was a finding of the GAL, it was a finding of the judge, and I think you have to look at that. We're not going to get a perfect situation. These are two people who couldn't get along and had an obvious lack of trust. And, you know, are things going to be perfect moving forward? No, they're not. They haven't been perfect up till now, but I think they've been pretty good. And again, if you look at the emails and the texts, you'll see that there were problems with certain issues, but, you know, I don't think we have a problem with COVID now. There may be problems with getting services and getting IEPs. The judge was hopeful, and I think that hope is probably well-founded, that moving forward things will be better. So I don't think we can set aside the judge's ultimate decision, either the underlying findings or the ultimate conclusions. I think they're very well supported by this record. Unless there are any further questions, I will ask that this court affirm the judgment.
Counsel, thank you very much. Thank you both. The case is submitted.
Thank you.
That concludes our session today. Our thanks to the court officers and the law clerks for all their help in allowing this to happen. We are adjourned. Thank you.